All right. Hello, everyone. I'm Stuart Clark,
And I'm Doreen.
and welcome to Holland Estates. You're listening to episode number 589. Well, hello, Doreen. Great to be podcasting with you again. Always fun.
Yeah.
So today we have, I think it's a relatively recent case from the Ontario Court of Appeal called Donaldson and Braybrook. We'll get the citation up somewhere close to where you're listening, that talks about kind of the issues surrounding a family cottage. A very common estate planning kind of headache of what happens to the family cottage. And this offers some kind of interesting insight into what can happen surrounding intention with the cottage after death. So I don't know if you can give a very basic kind of breakdown of family dynamics here, Doreen.
Sure. Cottage was owned by Mom. Mom has 4 kids. Their names are Wendy, Susan, Thomas, and Barry. By the time Mom decides to transfer sole ownership of the cottage to only some of her children, I guess even in our facts, there's sort of like no dad mentioned in the picture. In 1995, she decides to do this rather peculiar thing by secret. She owned it, and then she decided to transfer ownership jointly to herself, Susan, and Thomas. So only 2 out of the 4 kids. But then the other 2, Wendy and Barry, she decides to put on title as life estates. I say that she did this in secret because the kids weren't asked to sign anything, and nobody actually knew until after Mom's death.
Exactly. And so kind of in the same kind of time frame we're talking about here, Mom also for a number of years executes some wills as well, which also, at least in part, deal with the cottage. So as Doreen mentioned, back in March of 95, transfers the cottage so that it's held joint tenants between herself and 2 of the kids, and the other 2 of the kids are put on title with a life interest. So on the same day in March 95, Mom also does a new will, and for the important parts reference to the cottage, that will contained a clause that basically said that the residue of the estate was held in trust for 5 years, and that during that 5-year period, the estate was to in effect pay for any expenses associated with the cottage. Jump forward in 1997, Mom does another will, very similar to the other one, only now it has a 10-year trust clause. The estate's going to pay for the expenses of the cottage for 10 years. At the same time, she also, I guess she had, so Doreen said no dad in the picture. I guess she gets a new life companion, and life companion gets a right to live in the garage beside the cottage, not the cottage itself, but the garage apartment next door that he could live in. 2003, I guess relationship didn't go that well. She has a codicil, removes the right for the person to live in the garage, and then 2004, she does another will and removes any reference to the estate paying for this cottage at all. But as Doreen said, this is all kind of kept in secret. During this time, I guess Mom's living in this apartment next to the cottage, and all 4 of the kids at various times throughout the summer are coming to the cottage and using the cottage, enjoying the cottage, and then Mom passes away.
And when Mom passes away, or maybe just before Mom passing away, one of the daughters, one of the joint tenants, actually finds out about the ownership, but without knowing who is on the life estate. She realizes it's just her and Thomas on title with Mom, and then after death, they decide to sever the joint tenancy. They don't tell the other 2 siblings. Everybody actually just continues to divvy up the time like they used to when Mom was alive for some time. And it wasn't actually until Thomas decides to move away, thought, well, you know what, there's no point for me to actually own part of this Ontario cottage anymore. I'm leaving the province. I want to sell. Did this all come to light, actually, for Wendy and Barry, and then the whole matter goes to court after that. So this case, I think it's a really good illustration of all the things that can go terribly wrong when you don't tell your kids about what you actually want to do with your property when you're gone. A major component to estate planning is actually letting the people that you're planning for, letting them into that process, and then having those discussions before your death, and maybe letting Wendy and Barry understand why they were only given a life estate to begin with, because it is a very interesting thing to do with title, just to separate that full ownership, legal and beneficial, between Mark, Susan, and Thomas, and then only a life estate to Wendy and Barry.
Mm-hmm. And so as we mentioned off the top, this is a Court of Appeal case, which obviously suggests that there was an eventual appeal. The first time this thing wound up in front of the court, where Wendy was saying, hey, what the heck do I have here? I think, and Wendy's argument was basically, hey, I have a life interest on title, therefore I should have the exclusive enjoyment of this property during my lifetime. And when I die, it's at that point that the kids who got registered on title as owners their interest then springs at that point. But until, I am dead, I'm the only one who can use this.
Right, and nobody can sell without my permission.
Exactly. And the lower court agreed with Wendy. They said, you're right, you have a life tenancy, you're the only one who can use this. Now, if you flash back and remember from a couple minutes ago, before Mom's death, all 4 kids were using this cottage kind of, all the time. I'm assuming they probably had a schedule worked out.
And it was Mom who actually did the schedule.
Yeah, so all 4 were using it up until Mom's death. Mom dies, having done this, secret title planning. And now only one kid, Wendy, who's given the life interest, which, in theory is, the lesser of the interest than the actual proprietary interest, is now the only one who can use it.
Right.
Now, the other 2 kids, of course, didn't like that. They said, hey, I don't think that's right, and appeal it to the Court of Appeal. And lo and behold, the Court of Appeal agreed and basically said, you're right. Although this is kind of strange estate planning, if we take a step back and look at what we think your mom's intention was, we think it was your mom's intention that this is going to kind of stay the same as it always had been. The 4 of you could keep using the cottage during your lifetimes, and then once all of you have passed away, or at least the life tenants have passed away, then only 2 of the kids who have an actual proprietary interest in the cottage, and then their estates, assuming they're also dead, could then deal with it accordingly.
Right. Because it became a matter of who was going to get the proceeds of sale from this cottage at the end of the day. And I think another final piece I want to tie in is sort of like what happened to Barry. He was also named as the life estate with Wendy, but good guy Barry actually disclaimed his interest and, sort of let his siblings deal with it and died shortly before, I think, the lower court. But going into sort of the legal analysis that the Court of Appeal took, they really focused on what Mom would have wanted, looked into those wills as context, and actually in this particular case that the intention was so clear that they didn't have to think about the presumptions that come from the Supreme Court of Canada, the court decision, which is that there is a presumption that is held by the estate on resulting trust where no consideration was exchanged between parent and adult children.
Mm-hmm. Yeah, no, exactly. As Doreen mentioned, so PCOR, they very briefly touch on it. As Doreen mentioned, PCOR basically stands for proposition that where a parent and adult children own title jointly, it's presumed that the kids, upon the parents passing, are holding title for the parent's estate. So in this instance, if PCOR was applied, the 2 children who put on title, it wouldn't actually be their property. They'd have to return it back to Mom's estate, go out in accordance with Mom's will. The court said, well, look, it's a rebuttable presumption. We think it's so clear here that Mom didn't intend as property form part of her estate that we're not even going to get into an analysis of it. You've rebutted the presumption, and it is the intention. So it's at least an interesting question here, right? Because at the same time that Mom did do this property transfer back in 1995, we also have Mom doing this will saying, well, there's this 5-year cottage trust where my estate's going to pay for the cottage for 5 years. And I guess assume at the end of that 5-year period, you kids are on your own. But I mean, the strange fact that she's kind of doing this will, talking about the cottage, while at the same time dealing with the cottage title transfer, I mean, at least raises the question, well, why the heck are you doing all this?
Yeah.
But, I guess from the perspective, you know what? We don't care. We think it's clear what Mom intended, and we're going to make that order accordingly.
Right. And it did kind of seem like the way the cottage was used the whole time and Mom's role after this transfer meant a lot in the facts. And I also think even the description of where Mom lived with her partner and, how that relationship came in and out of Mom's life with the chronology of her wills meant something as well. So I think this, even from a practical litigation perspective, while it's all well and good to remember that sometimes presumptions don't arise when it's clear, was it ever that clear because it had to go to court in the first place?
Mm-hmm. So the important lesson, of course, to take away, and I feel like some kind of a kid show now, boys and girls, the important lesson to take away from this today is the importance of clear and concise estate planning, right? If Mom had done a will back in 95 or sometime later that just said, look, I'm going to have here's my cottage during my life, during, the lifetime of my 4 kids, it's to be, all 4 of you can keep using it. And then upon death of, these 2, the following 2 can have an interest in it. Everyone would know what was happening, or at least if she went and told the kids, look, here's what I'm planning to do. But she kept all this kind of secret without telling anyone, only allowing her kids to kind of try to piece it together after the fact through fragments of information from title, and it led to litigation, which could have hopefully been avoided if there had been clear language either in the will or clear kind of intention communicated at some point from Mom to the kids saying, hey guys, here's what's happening with the cottage after I go.
Right. Or maybe thinking about this problem in the way that when he won, how could she have been the only one to use it in her lifetime if nobody else knew about it, right? Like, if that really was your intention, that stuff needs to be communicated.
Mm-hmm. But no, yeah, it's an important lesson. Have a good estate plan in place. But also this case offers a kind of a refresher on, look, even in these complicated scenarios where, there's all sorts of information that's kind of being pieced together after the fact, the Court of Appeal, I think does a fairly good job here at saying, look, our job here is to take a step back, kind of say, okay, what the heck was Mom planning to do here? What was she trying to do with all these various pieces of paper and documents that she signed over all these years? And piece together, okay, well, we think that Mom intended that all 4 of you were going to use the cottage, and then it was going to go out to these 2 and implement that. So it kind of shows you, look, even in these circumstances where there's some chaos after death, the court can still step back and kind of say, okay, let's try to piece together what the heck was supposed to happen here, and hopefully come to a conclusion that makes sense.
Right. And so that's it for us today. You'll get the citation to that case on our blog. Until next time, we thank you for listening. I'm Doreen.
I'm Stuart Clark. And should you have any questions, please email us at webmaster@hollandhall.com. Thank you very much.